Good afternoon, Excellencies, ladies and gentlemen, dear colleagues, dear students. On behalf of the organizers, it is a pleasure to welcome you to our conference on Opinion 176 and mandatory non-mixity. As an introduction, just to give you a couple of explanations on the organization of this session. As you are aware, the webinar is registered and the idea is to have a lecture of about 30 to 40 minutes, which will be followed by a Q&A session. For that purpose, you have at the bottom of the screen the Q&A dialogue chat possible, so you are invited to put your questions in this box, so we can deal with it after the presentation. So don't hesitate to do it even during the very first part of the conference. It is really a pleasure and a privilege to welcome Professor Judge Allan Rosas for this conference today, which takes place in Geneva and Luxembourg at the same time, and all around the world for you participants in this webinar. It is worth noting that there is a great and strong interest in the issue we are going to deal with, in the competence of the European Union to conclude international agreements. You are more than 110 to have been registered for this webinar. We do have participants from academia, we have participants from practice, from diplomacy, and other governmental and non-governmental agencies. So a very diverse public for this webinar. Few words on the topics that is quite well known for some of you in this webinar. Opinion 176 relates to a draft agreement establishing a European laying up fund for inland waterways. You know that opinion played and play a very important role in all the discussion on implied competences, because the Court of Justice in that opinion ruled for the first time that there may be an EU external competence to conclude international agreement, even if there is no pre-existing internal rules adopted in the era which is supposed to be covered by the international agreement. Of course, this opinion 176 has been described in doctrine as the concept developed by the court of parallelism of competences, foro internal, foro external. However, as you know, this parallelism of competences has been linked to the necessity to enter into an agreement for the attainment of one of the objectives of the European Union. So this is really one of the, I would say, three main topics that have been dealt with by the court in that opinion. The second one is, of course, the participation of some member states to the agreement because of some specific reasons we are going to talk about surely with Professor Rosas. And the third topic, which is maybe less discussed today, it was very discussed also in the beginning of the 90s with the EEA agreement, which is the question about the creation of an organ, of a judicial body by the international agreement. And in this tribunal of the fund, there was the issue of the composition of the tribunal, which was settled as having in its forum judges from the Court of Justice of the European Union, and this was one of the difficulties for the issue of compatibility of the envisaged agreement with the treaties, and this was discussed in the EEA two opinions rendered by the court in the beginning of the 90s. So three main issues, but probably we will discuss more the first and the second one than the third, but of course we will see that with our guest speaker. Our guest speaker does not need any introduction. All the participants know him very well. I'm just going to mention one or two features and important function he is currently having. He is the chairman of the European Union 255 panel, and he is a member of the Independent Ethical Committee of the European Commission. On top of this, Allan Rosas is today a visiting professor at the College of Europe in Bruges and at the University of Helsinki. He is holding a seminar in Bruges starting in April on the dialogue between the Court of Justice of the European Union and the European Court of Human Rights. Very, very topical questions, of course, with the restarting of the negotiations between the Union and the Council of Europe. As you all know, he was judge at the European Court of Justice till 2019, and he is the author of many publications in European Union law, and in particular, what we are going to discuss today in the field of external relations. So without further ado, I would like to give the floor to Professor Judge Allan Rosas. Dear Allan, you have the floor for your presentation.
Well, thank you very much, Christine. I hope you can hear me.
Yes, very good.
I very much regret I cannot be physically present in Geneva, which is one of my favorite spots in Europe, but Luxembourg is okay as well. So greetings from Luxembourg. We have to live with this online conference method, at least this spring. Let's see what happens next autumn. Yes, I promised to talk about opinion 176, and in the title there's a somewhat unusual expression, mandatory non-mixity ? There's been a lot of discussion during the last years about so-called facultative mixity, or sort of a voluntary and optional mixity. And building on that, I'm going to ask the question, could it be that this old opinion could be of some importance today for a sort of a reverse situation? In other words, could it point to a mandatory non-mixity? In other words, union-only agreements, or then member states-only agreements, which of course always is an alternative. There is no need, and also to save time, to go into the details of the history behind all this, but so much maybe I might be or should say that EU external relations law and EU external relations case law really started in the 1970s, and as a background, as we all know, we have the famous ERTA ATR judgment already 6-7 years before, which not only confirmed that there may be an EU competence when there's internal legislation covering a certain area, but that competence also should be exclusive, as we have later called it. Then in an opinion 175, the Court of Justice recognized that common commercial policy is an exclusive competence. So if we look at today's Treaty of Functioning European Union, we can see the ERTA judgment reflected in Article 3.2 of the Treaty on the Functioning of the European Union. And then again, common commercial policy as a already ex ante defined area of exclusive competence in Article 3, paragraph 1 of the same treaty. Then we have the judgment in Kramer, 1976, the fishing and other biological resources of the sea, that built a little bit on ERTA, but did not, at least not as clearly as 176, which came 6-7 months later, what Professor Kadu already said in her introduction. In other words, that 176 really made it clear that there may be an external competence even if there are no internal rules. So this is the main difference and the main development as compared to the ERTA judgment and maybe also Kramer. Now, the 176 opinion, it was given in spring 1977, and one can in fact detect, if one wants to, 4 different aspects of that opinion. The first one, of course, is question of competence, and I will focus mostly on that, but it's very much linked to the question of mixity. To what extent is member states' participation possible and under which conditions? And so these are the 2 main aspects that I will deal with later on. There was also in the questions put to the court the question of delegation of powers. In other words, can the European Community establish an international organization or participate in an international organization, and then that international organization, which is not an EU body in the strict sense, then can it, that's a question, take decisions, maybe even decisions that are directly applicable and could have direct effect in the member states. And then there was this question of settlement of disputes. Is it possible, can the European Community participate in establishing an international court, which may consist of judges also from third countries. 176 was certainly quite important when it was given, and it certainly has continued to be important, but you could say that in the 1980s and still maybe in 1990s, it a little bit sort of fell asleep, or at least you can say that there were some question marks on exactly what it meant. And now it's maybe time to say a few words about the actual setup. What were the facts of the opinion? Professor Kadu already mentioned that it concerned something maybe not on the first sight extremely interesting or exciting, laying up fund for inland waterway vessels. There was an overcapacity of vessels in the Rhine and Moselle rivers, and then the idea was that you could lay up, in other words, not use vessels for a certain period of time in order to limit the overcapacity. And then if you were a vessel owner, you could be compensated by this international fund. And so this fund, which was meant to be an international organization, had two bodies, two more political bodies, and then there was a fund tribunal, so a sort of an international court. And that caused different questions. Well, I should also add, obviously, that it was very much a sort of a European community-centered enterprise, but why was it also an international endeavor? Because of the participation of Switzerland. And so there were 6 community member states, and then Switzerland. And one of the questions was it really necessary for all this to organize a new international organization with these powers to take binding decisions and an international court and so on? Could one not organize that in another way, or having some sort of bilateral deal with Switzerland, or could this have been done by the member states without the community and so on? So I'm sure there were many alternatives, but this was the route that was chosen. And to cut it short and not go into all details, one can say that the court answered the questions put to it in the following way. First of all, concerning the very question of competence, maybe the most important part of it, the court agreed with the European Commission. In other words, it said explicitly and fairly clearly that there may be an external competence also if there is an internal competence, even if that internal competence has not been exercised in the form of legislation or otherwise. And in that context, the Court of Justice used the expression necessary to attain one of the objectives of the community. So there was a condition. It should be necessary in order to attain an objective. But what does this word necessary really mean? It is something which in legal text is used in different ways, and necessary doesn't always mean really necessary, but this obviously I'll come back to. Then related to this first question about competence, that there was a competence, was the question of the participation of member states. There were 2 older conventions, Mannheim for the Rhine River and Luxembourg Convention for the Moselle River. And so it was thought important that the contracting parties to these conventions would participate, also because these new arrangements required or were deemed to require some amendments to these older conventions. But in the questions put to the court, it was sort of wondered to what extent this causes a problem more generally, because the member states had a quite important role in these decision-making organs of this new organization. And in one of them, it was only presence of member states. On the other, the commission was a chair, but without the right to vote. So the organs were really dominated by the member states. And the court, in its opinion, paid a lot of attention to this and used, in fact, quite strong language when you look at it from today's perspective, saying that this causes a big problem. Why are, of course, interpreting very liberally what the courts say, why are these member states there so strongly if it's the community which is a contracting party? And this is transport, this is international transport, it's one of the tasks of the community and so on. So when you read the text, you really wonder whether they are not sort of saying that there was an exclusive competence already because of the community became a contracting party. That said, it was noted that the participation of member states was okay to ensure that these old conventions were amended as they were contracting parties to them. But otherwise, the court seems to have thought that they should not have played the role that they played. So in that sense, the opinion was negative. Then on the delegation of powers, I'll be very brief. The court did not pay much attention to that, perhaps a little bit surprisingly. It said that in principle it's possible to create such organizations and they can have decision-making powers. But then the court said, in this case, these are more sort of management powers. They are not really important decisions. Something you could discuss, was that really the right assessment of these powers, because these decisions could be directly applicable in the member states. So it was not just any loose recommendations, far from it. But anyway, that was the court said, it's management powers. So there's no need to go into this question any further. But then last but not least, the court then noted that there's this fund tribunal, and there the court was a little bit struggling with the question: can the community become a party to such international courts? But the answer was that in principle, yes, and that's of course very important for the future. But then the court said there's a concrete problem, because it's proposed that most of the judges would at the same time be judges in Luxembourg, in the European Court of Justice, and that the court ruled out. It said that there already would be a problem with the quorum, because if a judge has taken part in Luxembourg in a case, and then something similar comes up in this new fund tribunal, or vice versa, then it would mean that you can't be judged twice, and there might be a problem with the quorum even. This negative stance on mixing roles for the Luxembourg judges, you can see in a later opinion on the EEA agreement, the European Economic Area, in the beginning of the 1990s, where the court also in its first opinion said no to such sort of a mixed court. Okay, that was really, by simplifying a bit, the court's answers to the question. And what has then happened later on, first of all in case law, and secondly in treaty law. In case law, we can find two strands how 176 has been interpreted. There was 194 on the community's accession to the World Trade Organization, and there's an OECD opinion 292, and then there is the Open Skies Agreement. Open Skies Agreement, but there was infringement procedures against 7 member states from the Commission's side. And in these judgments or opinions, 176 was interpreted as an exclusivity result. In other words, if it's necessary, then it becomes exclusive competence. But the court did not use the same criteria for necessity. So the threshold seems to have become different. In 194 and following decisions, it used the formula necessary in order to be able to exercise internal competence. So not necessary to achieve an objective, but necessary to be able to exercise an internal competence. Then we have, for instance, the ILO opinion, which 291, which seems to interpret 176 more as a question of just existence of competence, not exclusive, but existence of competence. So there was somewhat of a confusion, and we also have to add that in older case law, the court did not always distinguish between the two. It was only in opinion 103, which is on the Lugano Convention, which complements the Brussels I regulation, which is an internal EU legislation on recognition and execution of foreign judgments. And then for Switzerland, Norway, and so on, there's the Lugano Convention. And the question to the court was, is that exclusive EU exclusive competence or shared? And in this opinion, the court now makes a clear distinction, and I have to confess I was a judge rapporteur, between existence of a competence, is there a competence or not, never mind whether it's exclusive or shared or complementary or whatever. And then secondly, what is the nature of the competence? Is it exclusive, shared, or supplementary? Now, time has come to look at treaty law, and we can say that this distinction, which you see maybe more clearly for the first time in opinion 103 between competence and then nature of competence, is now reflected in the Treaty on the Functioning of the European Union. So in Article 3.2 of the TFEU, you have a kind of a follow-up to 176 in the form of an exclusive competence, because 3.2 is all about exclusive competence. You have 3 different criteria for an exclusive competence. One is the ERTA doctrine, if there's a legislative act of the Union. But then you have 176, or at least a certain interpretation of 176, which is saying, or is necessary to enable the Union to exercise its internal competence. And then you have exclusive competence when the conclusion is explicitly provided for in a legislative act of the Union. And I have to confess that when I saw the first drafts, I guess it was first of the constitutional treaty, but obviously that then later became of the Lisbon Treaty, I was quite surprised to find in Article 3.2 also a reference to a certain interpretation of 176. I had probably thought that what 3.2 will be about is the ERTA doctrine, more or less. So this aspect of 176, as it was interpreted in opinion 194, now we find in Article 3.2 of the TFEU. And where do we find, so this is the nature of the competence, exclusive, but where do we find the competence in itself, whether it's exclusive or shared? Well, we find it in Article 216, which concerns really the competence to conclude international agreements. And in subsequent case law, above all in the Germany versus Council, the Cotif 1 judgment, the court also has acknowledged this difference between 3.2 and 216. And in 216, you find the original formula 176, in other words, necessary to attain the objective. And the question is, are these two necessities the same? I would argue no, they are not the same. And in fact, it seems also that the Court of Justice would agree with that. The necessity test for 216 the threshold is lower, necessary to attain an objective. We find the same, more or less the same expression in Article 352, which is this old general formula for achieving legal acts, even if there's no explicit competence provided for in the treaty, but on the condition that the Council is unanimous. And there are nowadays also some other conditions. And there the necessity has been, at least in my interpretation, more of a sort of a political almost judgment, that if the Council unanimously decides that this is necessary, well, then it's necessary. And one way of interpreting also 216 would be to say that this is more a political than a legal question. But it's also possible to say that there is something a little bit more that is required, but nobody really knows, I think, exactly what. And in any case, and I would insist on this, I would say that this necessity threshold is lower than for 3.2. But now we come to facultative mixity, finally, because 3.2, as I said, is about exclusive competence. And there you have this formula that it must be necessary in order to exercise an internal competence. According to a very strict interpretation of this, this condition would never be fulfilled. And that would mean that there's a meaningless provision, or more or less meaningless provision in Article 3.2. I don't think one should presume that the legislator, or in this case, the Herren der Verträge, the member states, that they have wanted to create a provision which doesn't really mean anything because it can never be applied. You can always say, well, it's not, you can always use an internal competence. At least it's possible. It might be crazy idea, it might be not a good idea, but it's technically possible. And so if that's the criteria, then this would mean nothing in practice. And so I've been wondering, should one not assume that this has some meaning, and what would be the difference between this and the ERTA criteria? And in that context, then I picked up what in fact many wiser people before me have said, like Professor Eckhout in London, or my former colleague, former Judge Christian Timmermans, who have, and I must say that I have been more and more starting to think in this direction, which have been preoccupied by all the problems caused by mixity, both from a public international law point of view, but also from a constitutional EU law point of view, creating very strange constellations where you have also this incomplete mixity, there you have only a few member states parties, and how can you explain this from a public international law point of view that you have on the EU side not a sort of complete coverage of the whole agreement, and there are so many. I don't need to. I think most of you are familiar with this discussion about the problems of mixity, and I've asked myself, but it's at this stage more of a question than maybe a definitive answer. Should not this part of Article 3.2 be seen as something saying that there is not an exclusive competence from the very beginning? This is not like 3.1 where you have common commercial policy and competition law and so on, which are exclusive competence from the start. But you have a shared competence. And then there's a political discussion, should the union be a contracting party? Or should this be done by the member states? Of course, it can be done by the member states if it's shared. But if it's decided that it should be the union, I would suggest that this formula in 3.2 then would mean or should mean that in that case that should be, at least as a general rule, a union-only agreement. Of course, there's a condition to that. There can be no. First of all, it must be shared competence, not union 100% exclusive, because then that's another ballgame. But also there should be no member states exclusive competencies. If there are member states exclusive competencies, like the question of changing of borders, both the maritime border and the land border of member states, at the member states' competence. So if you do an international agreement where you change the borders of France and Spain, that arguably cannot be done by a union-only agreement. In fact, it's not a union competence at all. And if it's put together with some other shared competence issue, then it must be a mixed agreement. That's a so-called obligatory mixity, compulsory mixity. But if it's, as is very often the case, a shared competence where everything is mixed and you really can't say what is a union competence and what is a member state competence, then the conclusion would be that facultative mixity becomes obligatory, compulsory non-mixity. I've sometimes thought that 176 could perhaps be characterized as a sleeping beauty. And if that's the case, you could say that with this interpretation of 176, the beauty would have woken from its sleep. But I think only the future can tell whether that really will be the case, or whether we will continue with this very strange form of mixed agreements which cause a lot of problems for everybody. Thank you very much. I hope I haven't grossly overstepped my time, and that there still would be some time for questions.
Sure. Thank you so much, Allan, for this lecture. Excellent and insightful, with new interpretations, with new discussion. Starting opinion 176 is a 44 years opinion, and we have seen how often the Court of Justice has referred to that opinion in the case law that has been rendered after that opinion. I was thinking of opinion 215 as well. I must say, in the Singapore opinion, where the Court of Justice also referred to opinion 176 as far as the portfolio investment is concerned. And of course, it's very interesting to see how the court uses its own former opinion in that. But maybe before I would like first maybe to take the questions that are in our box, and we can come back to opinion 215 and to have your assessment of that utilization of opinion 176 in the Singapore. Maybe, Allan, if you agree, I can go through the questions that have been put, and I would just like to invite the participant to add questions, and we will try to go on. Allan, would you prefer that we collect some questions, 2 or 3, and then we have a round of answers? That would be
fine.
Yeah. Yeah. Okay. So I do have a question from Graham Butler, who is associate professor, and he is referring to opinion 176 and to opinion 191 on the agreement I just mentioned in the introduction about the EFTA, the EEA code that never existed, and that has been transformed in the EFTA code in the second version of the EEA agreement. And he's referring to this dispute settlement mechanism that are in different international agreements concluded by the Union. He's mentioning Ukraine, Moldova, and the opportunity to make preliminary references to the Court of Justice. So something similar to 267 TFEU, and he asked for your opinion on this. So comparison, opinion 176, opinion 191, and these new recent international agreements where we do have these preliminary references type of procedure contained in the agreements. So this is one question. Maybe the one I just launched about opinion 215 on the Singapore and the use of opinion 176 for the portfolio investment. That could be interesting to have your opinion, because it was this necessary use you were just mentioning. I do have a question from Marin Chamon, and he is asking a question about the recent opinion journal of Advocate Hogan in Opinion 119. So the Advocate General adheres to the idea that the Council has unfettered political discretion to decide to exercise European Union shared competence or not. But does the Istanbul Convention provide a good case to test the idea of mandatory non-mixity, given that it does not clearly fall entirely under EU shared competences? Is it realistic to expect the court to awaken the sleeping beauty in this case? So I think you have in Marin a very attentive, I would say, reader, Allan, in your publications, and I think it's vice versa if I saw that as well. So maybe we can take these three first questions, and you can start with this observation, and we have another round of questions afterwards. Please, you have the floor, Allan.
Okay, and the first question from Graham Butler on the international courts and dispute settlement procedures. Well, I don't have so much to say on that, except that I'm sure that my colleagues at the court, when they did the EEA agreement and ruled out this first version of the EEA court, which would have been mixing roles for some of the Luxembourg judges, that they looked at 176. So 176 really has been the one that in a way has sort of opened the gate for this kind of questions, and certainly also has had an influence later on the legislator and the council and the commission when international agreements have been devised. And then for the EA, the court of course accepted the construction in its later opinion, as there was the separate EFTA court created, which still exists. That as well in Luxembourg. On these preliminary ruling possibilities, I don't know exactly what was the question. If the question was whether this is possible, I guess opinion 100 then would be of some relevance, because there was this planned European aviation area, and there were countries that were not yet part or members of the European Union, like Poland and others, and there was also a possibility for non-EU member states courts to request preliminary rulings from the Court of Justice, and the court accepted that possibility. So it's an addition. On the other hand, the court doesn't like if tasks are taken away from the EU national courts, as you can also see from the Singapore judgments, but also from opinion 109, where an international court, patent court, was ruled out because it would have meant that the national courts in EU member states would have been deprived of some of their possibilities to put preliminary questions. So you can enlarge, but you cannot limit. Then there was the question of Singapore. Yes, also on Singapore and portfolio investment. If I'm not, I don't have that opinion in front of me, and my memory is short. But as far as I can recall, it's 176 is cited in this, should we say, 216 form. In other words, that it's a question of a competence, but it's not an exclusive. competence. So yes, you can also, this is a more general remark, you can say that 216, which lays down a competence, whether it's exclusive or shared or whatever, is maybe a more faithful almost repetition of what the court said in 176, whereas Article 3.2 on exclusive competence, or as I would say now, mandatory non-mixed criteria, is more a creation of, you could say, probably say opinion 194, and then what has come later, which is a more restrictive way of using 176. And then finally, there was Professor Chamont's question about Istanbul and Hogan. First of all, I have to confess, and that's also the reason why I haven't yet replied to an email from him. So, Merain, I'm sorry for the answer, but it will come. But because of so many other things I haven't had the possibility really to read carefully enough Advocate General Hogan's opinion. So it's probably wise of me not to comment on that, but maybe only to say that to the extent you could question whether Istanbul really is 100% typically shared, if that's the case, then it would not be a good testing ground for applying my thesis.
Thank you, Allan, for all these answers. Maybe I just wanted to refer to the discussion about Articles 3.2 and 216.1. These were largely discussed and analyzed in the FIDE Congress of 2018 that took place in Lisbon. And this is a publication that could be very useful for persons interested in the topic, because in this publication you do have the national reports, so the position of the national reports on that issue, plus the institutional report on these questions, as well as the general report. So this could be, of course, an important source of references and positions in the different member states of the European Union by different authors and academia. That is, of course, one thing that can be referred to here. Well, we can take another round of questions. If I take them just in a chronological way. We do have a question here from sorry, I'm speaking a bit of German, of Pierre Reynaud. How would you envisage the issue of mixity under 4.3 TFEU, for example, in space, considering that this article only refers to activities, not objectives? Would Article 4.3 TEU arbitrate in that case? So that means these are linked to, of course, the objectives, and we will have a look at this. So this is one question. I have a question related to the TCA, so the Trade and Cooperation Agreement with the UK. So this is a question from Philippe Muscat. In the light of the explanations given on opinion 176, it would be interesting to have your opinion, Professor Rosas, on the opinion of the Council Legal Service in relation to the TCA. I don't know if you were aware of the opinion of the Council's Legal Service, of course. So this is a second question. And I do have one in relation to Article 3.2, which says at the end, it is within the limits outlined by Professor Rosas, a political decision. So the political decision, isn't there a similar understanding of potential competence in the Council Legal Service opinion on the UK European Union agreement, according to which eventually it is the Council decision about mixity or EU only. This is a bit like Gotif, but I let it to you, Allan. So we have 3 questions, please.
Okay, so the first was on Article
4.3.
4.3, yes, in the areas of research, technological development, and space. That's what is sometimes called a sort of supplementary competence.
We should be a parallel competence, in fact, yeah.
Yes. Well, it's shared in a certain way, but it's not the sort of typically form of shared mixity. To be frank, I haven't thought about this. I have been thinking mainly about the sort of normal shared areas which are listed in 4.2. It's not an exhaustive list. There can be also other things which are not clearly covered by 3. My improvised first reaction would be that what I said would apply also not only to 4.2 but also to 4.3. But that said, well, no, I guess it wouldn't. I have to retract because there's this explicit end of the text that competence shall not result in member states being prevented from exercising theirs. Well, maybe I leave it at that.
Mm-hmm.
And then the Council Legal Service opinion, I'm sorry, I haven't read it. So yeah,
I haven't read it either.
That's good to know. And then there was, I think, something linked to that about 3.2, but I'm...
Yeah, it's not very...
kind of to repeat.
Yeah, please, I can do it. So this is, so the question is written like this, Allan, at the end. So it's the reference to the political decision you were talking about. Isn't there similar understanding of potential competence in the Council Legal Service on the EU-UK trade agreement, and according to which it is the Council decision about mixity or EU only? But I didn't see the legal service opinion, and probably if you didn't either, then it's difficult to take any position on this. So I don't know if the person wants to give more information on that. That could be, of course, one issue. I do have another question in the discussion box, so the other one, which is how Professor Rosas see the consequences of the Protocol 21 and 22 of the exclusion of Ireland and Denmark in relation to the compulsory non-mixity. Probably you might know from where the question comes. Don't know.
Well, it's better not to guess even. Well, that's prime. I mean, the protocols are primary law. So what I'm saying would not, I was speaking at the level secondary law, as it were. So, and in any case, to the extent that we are asking whether 3.2 somehow could undermine or influence the application of these protocols, I would say that these protocols are a sort of lex specialis. So again, I'm improvising, but I think what I was saying would not, at least not directly apply to or in any way affect the application of these protocols.
Okay, thank you. I do have other question. I'm sorry, I'm having so many questions that I have to go through them. It says, we do have a question because of a lot of national states are building the business and security, and some national are becoming the commissioners. So there is sharing. Sorry, no, I'm discovering the questions at the same time, Alan. That's why. I would rather go to a question which is related to the Energy Charter Treaty. And there is a question of Julia from Geneva, Julia Kasparovich from the University of Geneva. And her question is about the nature of Energy Charter Treaty Agreement. Might that be a case for a mandatory non-mixity after upcoming court's opinion? I don't know if you would like to answer this question, maybe, Alan, starting with this one.
I have no idea what the court will decide, but I would simply say that I suppose if the Energy Charter Treaty would be concluded today, then at least one should ask the question, is there something which is exclusive member states? And if that's not the case, then what I said about 3.2 and mandatory non-mixity would certainly apply also to the Energy Charter.
Mm.
That is, of course, not what was done, but they hadn't listened to my lecture when they did the Energy Charter Treaty.
Yes. I was thinking of one point. I don't see any new question for the time being in the chat, but listening to you, Alan, I was thinking on the relationship between ERTA, so the ERTA judgment that will be 50 years old next Wednesday on the 31st of March, 1970, which was rendered in 1971. So, because in the ERTA we have these internal rules adopted by the institutions, and the formula of 3.2, we have one which is necessary to enable the union to exercise its internal competence. It's almost, I mean, it is. You have the pre-exercise in ERTA of the competence, so internally. And in 3.2, you have the exercise of the internal competence alone, if I may say it, without being pre-existent. And this is exactly what the Commission was trying to develop in Opinion 215 as far as portfolio investment were concerned, because the Commission said first, of course, she tried the express, and then the express competence, and then subsidiary the application of Opinion 176. But it tried also to use the ERTA, saying that we don't always need the pre-existence of internal rules, and this, the court did not go into this. And do you think that this is still the case today? I mean, according to the 3.2, is still different from the ERTA. So we have ERTA, we have 3.2, and we have the different meaning of 216, as you mentioned before. So we have, in fact, 3 different scenarios, even if we are in one part talking about the existence of the competence, and in others, the exclusiveness of the competence. So it's, but
yeah, first of all, in 215, the Commission was also arguing that the provision in primary law in the Treaty of Functioning European Union capital movement could have an ERTA effect.
Yeah. And
the court, of course, said no to that. But then going to the relation between ERTA and 176 inside 3.2, because both are in a way reflected in 3.2, I would say that if this is a sort of a academic schematic example, but if you have 80%, 90% of the area covered by internal legislation, then you probably have ERTA, because the court have said that if a sort of substantial part is already covered, then you don't need to have 100%. But if only, to take that example, if only 50% or 30% is covered by internal legislation, then you could ask, well, okay, this is not from the very beginning exclusive, but does it become mandatory, non-mixed because of the 176 criteria as it is formulated in 3.2? Then 216 for me is something clearly different, because that only concerns the existence of a competence. So we know for mandatory non-mixity, as I called it, it's 3.2, which is really the central provision.
Yeah. Okay, thank you so much, Allan. I think we are close now to the end of this session. It was really very, very interesting discussion on this case law, and we see how much interest is still in these very first opinions rendered by the court. It was the second one. There was only the opinion 175, which was the very first one rendered by the Court of Justice, and this was the second one. And we can see today how much interest is still in these old, I would say, case law of the court, and how the questions are still pending. So we see how these issues of competences is really at the heart of all European Union and member states' competences in terms of constitutional EU law and in terms of public international law. And we see how much today these interaction of European Union law and international law is increasing in all what we discuss. If I think of the field of trade, what we can see in the new generation of free trade agreements concluded by the Union with third countries, and how much of references to international mechanism, more international mechanisms are brought into European Union international agreement are now present. So I think these kind of discussion we had today are going to increase, and the interest of really understanding the combination of European Union and international law is fundamental and essential to deal with future relationship between the Union and certain countries. And you might know that Switzerland is at a very important moment that is discussing also an international agreement on what we call institutional potential draft agreement on the future relationship. Well, with these words, I would like again to thank you very much, Professor Rosas, for this lecture and for this very interesting discussion we had. I would like also to thank all the participants for the questions and the comments in the different boxes. It was not always easy for me to deal with all these questions, but I did my best. And I would like also to thank Elizabeth Ruiz-Quero. She is a doctor in law from the University of Geneva, and she helped us to organize this event. So thank you for this joint webinar from Luxembourg and Geneva. And I hope, Allan, to be able to welcome you to Geneva physically soon when the sanitary situation will improve. Thank you. Thank you to all.
Thank you very much, and I'm looking forward.
Thank you. Thank you. Goodbye, everyone. Thank you.